May I take advantage of the knowledge, wisdom, experience of Justice Azcuna, not only as a former Supreme Court justice, a recognized legal luminary, but as a member of the Constitutional Commission. Sir, can I take a step back? When the Constitutional Commission discussed the Bill of Rights, and in Section 2, the rights of the people to be secure in their persons, houses, papers, effects, against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant arrest shall issue except upon 1. Probable cause, 2. Be determined personally by the judge after examination under oath of affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the person or things to be seized. Am I correct, sir, that this was also a reaction to a period in the martial law where there were different kinds of warrant of arrest? Diba yung, I don't know the name of all of them, but ASO, so there were arrest warrants from many sources, including the military. So the commission, in its actions as representing the Filipino people, so fit. At least ito po yung tinuro sa amin sa Ateneo Law, that ang pinaghugutan nito, to be sure that if someone is arrested and it's not on a whim, it's not politicizing whatever, we will make sure by 1, judge lang ang pwede sa Pilipinas ang mag-issue ng warrant. Of course, the Supreme Court has already said may exception like the Bureau of Immigration just for the foreigners. But in general po, it has to be a judge. He can only issue it upon personally determining that there is probable cause after examination under oath of the complainant. Am I generally correct, Mr. Justice?
That is correct, Mr. Senator.
Yeah. So that is why in our 14 treaties for extradition with other countries, pare-pareho yung procedure that after the DFA receives the request for extradition, pupunta muna to sa isa nating judge. Para yung judge pa rin ang titingin. Am I correct? Am I wrong, SOJ? Tama, no? So that the judge can double check, and then he will be the one to either confirm or verify or issue the warrant of arrest. Then yun ang isa-serve ng local police. That's my understanding.
That is correct, Mr. Senator. The need for a judge to be the one issuing the order in cases of warrant of arrest and even search warrant is enshrined in our Constitution, because there were previous occasions prior to our adoption of our Constitution where instead of a judge, a justice, an authorized officer. So it has to be a judge. In the case, however, of the ICC, the warrant of arrest was also issued by a judge. In fact, 3 judges issued the warrant of arrest under the ICC. Question is whether or not that warrant of arrest can be executed in the Philippines by Philippine authorities. And that is, I think, pending the Supreme Court now. There are pros and cons on that, but one issue there is whether or not the 3 judges pre-trial chamber of the ICC acted on probable cause or merely on sufficiency of evidence. Yes. But as I said, the provision on probable cause and the judges issuing the warrant are procedural safeguards that are good only for the forum and not applicable abroad. That is the limitation. Our Constitution does not extend beyond our territory. Thank you.
Point I was going to, sir, is really the legal remedy of a Filipino citizen to run to our judiciary, which I ask Attorney Alexis Medina and go to him later. But my point, I think you already read my mind, Mr. Justice, and because you were saying we are not sure whether the judges or justices of the ICC went into probable cause or sufficiency, because we are also not sure if they issued the warrant based on a personal determination of the witnesses or complainants under oath. We do not know whether these are media reports or whether their prosecutors came here and interviewed them, no? So ang point ko, Mr. Justice, if I was being arrested and I'm not sure, I should be able to go to Philippine courts. Sa extradition treaty, sir, judge din naman judge ng US, judge ng UK ang nag-i-issue nito, no? And I checked with the ICC versus the other countries that signed with them. For example, the United Kingdom, no? It is the appropriate judicial officer who will issue the warrant of arrest of the UK. So from ICC, ido-double check pa rin ng ano. Ganon din po sa Canada. The Attorney General will apply ex parte for a provisional arrest before a judge. So it's not the fiscals, it's not the Prosecutor General. The Prosecutor General's job there is to bring it before a judge. Ganon din po sa South Korea, ganon din po sa Argentina, ganon din sa Paraguay at South Africa. That is why if we look at the information of surrender and transfer sa page 8 po. Number 8, sorry, not page 8, number 8. Nakalagay po dito, the date, time, and location of the appearance of the arrested person before the competent national judicial authority. Ang sagot po dito na ang pumirma, if I'm not mistaken, si Ambassador Lacanilao, do not know. So he did not know when he surrendered the former president whether they were brought before a judicial entity. So yun po yung main issue ko, Justice, na ang pagkaintindi ko, kung meron pong dispute sa interpretation ng batas or even sa issue of application of the law to certain facts, a Filipino citizen at any time can run to a Philippine court. But in this case kasi, he was denied the opportunity to run before a Philippine court because he was put on a plane and sent there, no? So even assuming I agree with everything you said now and I see the legal basis naman nung sinasabi nyo, sa akin, that remains to be the question on my mind. Can we deny a Philippine citizen the opportunity to go before a Philippine court? According to General Torre, and he can rebut this later on, is that 8 or 12 hours is enough, diba? But I think mas malaking issue yun kung ang court nag-issue ng TRO within 8 or 12 hours unless the circumstance. I think at the time na the lawyers applied, hindi nga nila alam na isasakay sa eroplano diba? But I leave it there. Feel free to comment, Justice. Ang point ko lang po, I think the spirit and letter of the Constitution is clear. It has to be before a Philippine judge to determine this, no?
In fact, Mr. Senator, the procedure in the ICC calls for bringing the person to a Philippine court first before surrendering the person to the ICC. So if you do not follow that, it can be argued that there is what they call abuse of process, and an abuse of process can be raised in the ICC itself. I think this is what will be considered in the September hearing scheduled by the pretrial chamber. Under the rules, objections to the legality or objections on abuse of process may be raised and resolved by the pretrial chamber, probably at the scheduled September hearing. So this remains still open, even in the ICC. The question of the validity of the surrender in view of the non-observance of Article 59 of the statute of Rome itself. And the other thing is whether or not such abuse of process is curable. And again, that is debatable. It seems to me that the initial hearing on March 14th done by the pretrial chamber was an attempt to cure the deficiency of the absence of Article 59 procedure, because the three judges of the pretrial chamber in that hearing simply did what a local court would have done. That is, determine that the person is the same person named in the warrant of arrest, and that the person was informed of the charges against him or her. And after that, they said session adjourned. So they merely supplied the defect that the absence of the custodial state's local court created. So it remains whether or not male captus bene detentus will be applied by the ICC.
Yes.
Thank you.
Mr. Justice, yung dahilan kung bakit, yun ang tanong ko, no? The reason for my questions is, I grew up dun sa naririnig mong sa presinto ka na lang magpaliwanag. And after the EDSA Revolution, eto sa bagong constitution, then the many laws we passed after addressed that eh. Hindi pwedeng bigla ka na lang hulihin tapos sa presinto ka na lang magpaliwanag. Unfortunately, parang yun ang lumabas, sa Hague ka na lang magpaliwanag. Even if there are defects here. But I just like to express my admiration, the way you explain very fatherly, whether it's in class, it's in the Supreme Court oral arguments, or here. Thank you for